Thank you all for coming. I'm calling to order today, July 25th, 2013, the 72nd public meeting of the Massachusetts Gaming Commission. As you know, we will conduct our regular public meeting. We will then adjourn that meeting, and we will then move to an adjudicatory hearing on suitability applications. We will start with the approval of the minutes. Commissioner McHugh.
The minutes have been distributed or in packets. I move their adoption as circulated.
Has everybody had a second?
I second that.
Has everybody had a chance to read them? Look all right?
Yep.
Yes.
They keep getting better and better as far as I'm
Yes.
concerned, you know, more
Excellent.
buttoned up each time. Any other discussion on the motion? All in favor of accepting the minutes as presented?
Aye.
Aye. Opposed? The ayes have it unanimously. I think item number 3, an administrative catch-up from Executive Director Day.
Chairman, Commissioners, good morning. And
morning.
I think as I'd start, I just wanted to mention that our next meeting is on August 9th, just for those watching and on live stream, and in the audience today, as opposed to the 8th meeting, and it'll be at 1000 Washington.
You're right, just our ordinary every 2-week meeting would be on August 8th. We have changed that to August 9th, Friday, August 9th, and it will be at 1000 Washington Street for those of you who attend many of these meetings. Thanks.
Thank you. Chairman Crosby, it is my pleasure this morning to start out by introducing our first Director of Licensing for the Massachusetts Gaming Commission. David Acosta is sitting next to me here. David starts with the Commission on Monday, and we're eagerly looking forward to his presence. And he comes to us from the Ohio Casino Control Commission, where he was Director of Licensing. In fact, David was responsible for setting up Ohio's licensing program. Prior to Ohio, David was employed by the New Jersey Casino Control Commission and involved in casino employee licensing for 27 years. We feel very fortunate that David is bringing his knowledge and skills and experience to Massachusetts. So I'd like you to join me in welcoming David, and perhaps he has a couple words of wisdom to say to you before you start this morning.
I hope he's got more than a couple.
Commissioners, Chairman, thank you very much. I'm excited to be part of this team and looking forward to working with Director Day and the rest of the Commission staff. Like he said, I'll be here Monday. I'll be hopefully the first one in, last one out, getting my feet wet nice and early. I thank you for the opportunity and look forward to working with each and every one of you. Thank you.
Great. Great to have you here. Any questions or comments from any of the commissioners?
Well, I just want to say, David, I think we're fortunate to bring your talents to Massachusetts. I know from folks I've spoken to in New Jersey, you have an excellent reputation, had a great working relationship with the New Jersey State Police and all the other folks at gaming. So I am happy you're aboard, and we look forward to right away utilizing your expertise.
Thank you.
I second that. I've not had the pleasure of meeting you, but I look forward to meeting you more informally. But your arrival is very timely. This is right on the edge of what one of our next big steps is, and your background and your resume surely indicate that you have the expertise that we need to take advantage of in order to get it done efficiently and well. So, welcome aboard.
Others?
Just to echo the same comments, thank you for being here, and we're very excited about the next step, one that has a lot of work to be done. So we're happy to have you here.
Very happy to have you on board and pull on your experience in helping the folks in Ohio get up and running. And I'm sure Director Day, as he's a transplant, also has told you about the pledge you need to make to support all Boston sports teams.
Ooh, sore
As
subject.
part of your employment.
Is that a condition of employment?
He quickly went silent, but that's fine. Welcome aboard, Dave. We're happy
Has
to
he
have
signed his agreement letter yet?
I think it's the Eagles, right, David?
Yeah, well, the Flyers.
And the Flyers, yeah, okay.
Oh,
It was a condition on the second page.
David, I just have one question, and Director Day knows that this has been something we've been talking about and concerned about, and it's sort of a rhetorical question, but it sort of sets the stage. We expect to award the slots license by the end of this year, by the end of December. And we are told by some of the bidders that they could be up and running as soon as 9 to 12 months after that. That means that we'll be needing to start your licensing process probably on January 1st and be fully ready to go for operations of a facility within 9 to 12 months thereafter. How does that time frame feel compared to what you did in Ohio, what you know needs to be done? We have done a tremendous amount of work in licensing applicants. We've done zero work in preparing to license everybody else that has to be involved, the individuals, the companies, and so forth. How does that schedule square with your experience?
I got to Ohio in January. The first casino opened in May.
Okay.
So I was asked to put a license division and all of its process investigation and license about 2,000 people in about 5 months period of time. So that was crunch time. Giving me more time than 5 months would be a real pleasure.
That's a good answer. Thank you. And Director Day has reassured me that my concerns are exaggerated, and it sounds like they are. So that's good news. Anybody else? Thank you very much, David. Great to have you here. Welcome.
Thank you.
Thanks again, David, and it is great to have you here, and I know you've got plans, so we'd enjoy having you stay as long as you can, and then anticipate to see you Monday. By the way, I'm sure the commissioners have noticed that David's resume is included under 3A, if you had a chance to glance at it. Chairman Crosby, I'll just go ahead with the items listed.
Yep.
If that's all right. The next thing I'd like to touch on is the project manager coordinator recommendation. As I previously noted, we had posted a procurement for the project manager coordinator for Category 2 license applications evaluation process, and by extension to Category 1 when we get there. We received the responses on July 11th. We reviewed the responses and cleared the evaluation or the process for completeness. They're distributed to our procurement team, which of course is Commissioner Stebbins, Richard Henderson, which is helping us thanks to Bruce, and myself. The team met on July 18th to review the responses and score the proposals. 2 responses were selected for oral presentations, and oral presentations took place July 24th of 2013. The procurement team finalized the scores after the presentations and reviewed costs for services. And at this time, there is an apparent successful bidder. As we're closing in on the end of the process here for today's commission meeting, we'll be reaching out to the apparent successful bidder references in the next 2 days, and provided there are no surprises during the reference check process, and in order to make sure we have a coordinator involved in the selection of our advisors, I'd like to request the commission to provide me the authority to make final approval for the contractor, delegate that approval to me if you would consider that. Of course, we would ask the successful bidder to be available to meet with the commission at its August 9th, 2013 meeting. But in order to make sure we get the reference checks done, I think that's critical to the process, and then be able to move ahead to have this individual or individuals on board as we begin to select the rest of the advisors. It seems important that we be able to continue to get that decision done if the commission would be willing to do that. I would like to as well, and I know Bruce has informally, Commissioner Stebbins has informally thanked Richard Henderson for helping us with with the selection process. He also traveled to Commission's office and sat in with us during the personal interviews, and was a great help with his expertise as well. So hopefully you'll extend that again to him for me.
I will.
I don't think there's any issue about delegating the decision-making authority. I don't think we need to do anything formal about that. We've already done that in a number of cases, and we're totally fine with that. What about the background check, though? Has that been done?
The background check has not been done. What will be part of the preliminary process as we start forward. So there, as we do in many cases, there'll be a preliminary and then an approval based on completion, the actual completion of the rest of the background.
Okay.
So,
All right, great, thank you.
what I'd like to do is move to the next item, which is the consultant contract recommendation. I think the commissioners recall that we extended our Spectrum, Michael and Carroll consultant contract through fiscal year 2014. The idea was to allow for time to discuss future arrangements. Not to mention, we were at the end of the fiscal year and need to make sure that we kept that contract active. If it's acceptable to the commission for the first quarter, after discussions with the consultants and Kathy O'Toole, for the first quarter of 2014, we would propose that the retainer be reduced by 25%, and then at the same time, the consultants will track and report hours worked and topics for the Gaming Commission. The idea would be that data will be reported to Kathy O'Toole, who will continue to coordinate work referred to the consultants. Kathy will review the data that we then collect with me in order to determine the most appropriate level for the retainer in the future. So short term is that we'll continue the retainer with a 25% reduction. We'll collect the facts during that period, make a judgment from there based on what the facts tell us about the retainer and what level it should be at.
Are you've concluded that there will be a retainer? It's not going to be an hours upshot? I mean,
Yes.
You're saying that for the next 3 months, but are you saying that for the future as well?
No, what I'm saying is that we'll take a look at what the hours and actual hours worked looks at as comparison to the retainer, and then we'll make a decision based on which is most beneficial to the commission.
Okay.
Go ahead.
I'm particularly interested in, as we do this, that we identify the efforts and hours, and therefore the compensation fee that is relative to evaluation, that can be assessed to our investigations phase 1 and investigations phase 2 process, because we have taken the approach that all of those monies will be assessed across our applicants, as opposed to the general consulting and advice costs that come out of our the pool of money that we have until we can assess our licensees. So I'm particularly interested, in learning that. I think it's a good approach generally, that what you described, but if during this period we need to call out or anything relative to investigations phase 1 and phase 2, I'd be very interested in that.
No, that's a good point, Commissioner Zuniga, and I have talked with Kathy about that, and I think it's important to be able to do that, focus on a method to do that as we move forward. I think for the most part, this proposal, our own destiny is in our own hands, because obviously the amount of hours and the amount of work will have a lot to do with which one's more advantageous to the commission as we move forward, whether it's an hourly or a retainer.
You know, this is obvious, but I'll say it anyway. We've expressed many times our great satisfaction with our 2 consultants, Michael and Carroll and Spectrum. I think we've gotten, the Commonwealth has gotten its money's worth. On the other hand, there's been a lot of money that's exchanged hands here for a lot of work, but we do need to make sure that this analysis is rigorous, just because it's a lot of money.
Thank you.
Okay.
The next item would be the procurement chart, and really this is essentially informational. The commissioners, Commissioner McHugh, request our various evaluations. We can put that on one chart. It's included in your packet as item D. Essentially what it does is it lists the 5 major procurements: financial advisor, project coordinator, building site design, mitigation, economic development, and document management. Those are the ones that the large ones the commissioner are currently involved in. The chart also lists key dates in the procurement process, and we plan to bring the financial advisor for approval in late August, the other 2 advisors in early September. The idea is to be able to consult with our project coordinator on these selections. We also anticipate the document management system in mid-September. So hopefully that'll supply. The idea was, as we were moving that chart forward, that it also contains some information, let the commissioners know a little bit more about the procurement and when those key steps are scheduled and planned.
I would just like to make a note that two dates here as they refer to the financial advisor. I didn't have enough time to bring this up prior to the packet being out, but the last two dates are not the 19. We did conduct the oral interviews, the oral presentations of the financial advisor on the 22nd. That's an actual, but the cost review and the best and final offer we have not yet concluded. But the final recommendation projection is correct here for August 22nd.
Okay, thank you, Commissioner Zuniga. Any other questions on the chart? The master schedule, if we could go to that, and I neglected to borrow a pointer for this process. There happened to be one handy. Although it takes a very steady hand anyway.
Just give it back.
Cause great entertainment from the back. Okay, what I'd like to do is we have, with the master schedule, and you all should have a version in the packet. What I need to talk about in particular is the category 2, which should be this right here, which is the suitability determination process. Essentially, the basic dates remain the same, which is the August 29th date that we anticipate being concluded with the suitability process for category 2. The difference in this chart and what I'm recommending for how we reflected on the master schedule is, instead of having this period in here, as you may have seen it before, we tried to pick dates or have dates for specific hearing dates. We found that that's a very fluid process, and there's different kind of hearings involved, whether it be the public hearing or adjudicatory hearing, and each one of those take different time, have different facts associated with them, so it makes it almost impossible to actually predict when those might occur within the process. So what we've done is just made that a process to have the project completed. We started in 7/11. We anticipate being done by August 29th. That is still should be a very doable date to have the process completed. That change is also similar if you look at category 1. The difference in category 1, though, is we have, and we talked about that a little bit before, which is this period in the chart here. We had at one time had the date for starting that rolling or as completed presentation. We thought we'd be in there pretty close to early August 5th, I think. Last time around, I talked that those dates are probably not very realistic. I think we're a lot closer to what we reflect here right now. We're hoping to be able to start the process on August 22nd. And again, what we did is eliminated any specific dates in between and just identified it as a process here that will begin at August 22nd. We're very hopeful of that date. I have to say, although that is optimistic, because it depends on, as you know, the complexity and the type of reports that are there, but we still anticipate completing the process. The important thing, again, is that process will be completed by 11/30, and at this point, that seems to continue to be realistic for this part of the schedule. The other thing that I just wanted to check in with the commissioners, we have 12/31 as the date applications are due. There was some discussion, and a little bit on the last chart, is there was some discussion about whether or not the holiday there was going to should interfere with the schedule. What ultimately it looked like to me is that the commission had reaffirmed it, and they deliberately kept the date for the applications to being due on December 31st. That doesn't mean, though, it won't be December 31st at 2, as opposed to any later on that day. But we thought it important to hold on to that date as we move forward. So the date applications are due for category 1 continues to be December 31st unless the commission decides on some change. The last item here that I think is important to note is in the Region C, Category 1 schedule, and this is just a sort of a forewarning, is August 15th. We're projecting to begin the scope of licensing, scope of licensing part of the process. And this is for those who anticipate submitting a Category 1 application for Region C. That provides them the opportunity to meet with staff and our investigative assistants and discuss what might be appropriate relative to qualifiers that need to be submitted. So that was important here to at least mention that as we get closer. It's really only about 3 weeks away. With that, that's the updates. If there's any concerns or questions about those schedule issues, I'd be happy to address them, and if I can't, call on some help.
Anybody?
I would like to emphasize something we've talked about, but that is it's a milestone that will happen before our next meeting, which is the August 5th date here, which is 60 days prior to our deadline, by which a host community has to be, for the Category 2, by which host community agreement has to have been executed and then a referendum scheduled. So before our next meeting, we will effectively know who has a scheduled referendum, and he's essentially still in the mix, I guess.
And this will probably happen, but maybe Ombudsman Ziemba on the 9th could give us and we'll probably have it before that, but give us the final on who made it, who didn't, what's coming for each of the 5 bidders.
We have that new, the kind of the schedule that combines all that date would
Right, which is
probably be a
great.
very handy method to
Right,
provide.
which is also now on our website. Director Driscoll has put it up on the website too, but yeah, it's great. Anybody else? I just had, so if looking at Category 2, the slots license, which is the one that interests most people in the room at the moment. So what, if I'm reading this right, what you're saying is that ideally we would make the decision, the award in the middle of December, but if there are extended negotiations and arbitrations relative to surrounding communities, that could force it out a month and a half later.
That's correct.
Okay, so we don't.
That's right, this part.
We don't know yet whether we'll have any debates, any arbitrations on surrounding communities. If we don't, we would be able to make our deadline, but if the bidders aren't able to negotiate deals with the surrounding communities, that could delay the schedule.
That's correct.
Yeah, okay. Great.
Yeah, the dates I mentioned in the suitability process, the end date, other than having some impact, obviously, and most of the applicants have went forward with that early section of the being able to take advantage of the election before the suitability determination. But that is one thing about the changes I talked about. None of those would change the actual planned dates for award license.
Great.
Unless the commission has something else for me, that's the end of my report, and I can turn this over to Director Dernberger.
Okay.
Thank you.
Thank you.
Thank you.
Let the record reflect the pen was returned.
Yes, thank you. The magic pointer was returned. Director Dernberger from our racing division.
Hello, Mr. Chair, Commissioners, how are you?
Oh, very good, thank you.
Racing administrative update for this morning. First, I just wanted to update you on milestone in racing, and that has to do with our equine drug testing
Excuse me
program.
one second.
Yes.
Can everybody hear all right? In back, raise your hand if you cannot hear. Okay, great.
Thank you for checking. So in Massachusetts, 2 horses out of every race are selected for post-race drug testing, something that not everybody realizes. And you, the commission, approved an RFP, a competitive RFP process over the winter. And a new testing laboratory that's accredited to industry standards was selected. So to date, we've submitted just over 1,100 samples for testing. And this week marks the 1,000th sample result received. So I just thought I'd give you a quick update. Our industry now, and Massachusetts has adopted this model through this commission. We distinguish between prohibited substances, which are those substances that have no business being in a horse on race day, and therapeutic substances, which are acceptable but only when present below a certain threshold level. So I'm happy to report so far, we have no findings of prohibited substances in any of the horses selected for testing in Massachusetts. We have 10 adjudicated findings of therapeutic substances present in post-race samples above the permissible concentrations. And the take-home message here is that this incident is only just slightly higher than what we see nationally, and I think that's a tribute to our horsemen and our veterinarians, given the enormity of the change, both in our regulations and in our testing process for this year. So I think, remember, up until this year, it was still permissible in the Commonwealth of Massachusetts to administer anti-inflammatory medication on race day, and we've backed that out to at least 24 hours out now. So we've removed that important asterisk, I think, from the industry's drug and testing story that we have to tell. We did that before the live racing season began, and I think that our program is a tribute to the success of the stakeholders in compliance. So I wanted to get that out there.
Could I ask
yes.
a question? That's terrific. What are the consequences, if any, of finding a level of permitted substances above the approved level?
So the current regulation that Massachusetts has adopted, and it is the model rule, divides those into two categories of severity based on that concentration. And the distinction we make is between levels that are slightly over. So in other words, those are usually attributable either to individual metabolism problems with the horse or bioaccumulation. Somebody's been feeding it too much too often. Somebody got a little bit close. Those kinds of things. And then the aggravated category, if you will, is a level that would indicate somebody tried to do something on race day. So an intentional administration or a mistake that resulted in a double administration or whatever. But the effects on that horse and on the race itself are significant. So the two different categories, the recommendation for a first-time offense on the first category is a written warning up to a fine. The aggravated category does have some more significant consequences, including up to loss of purse, which is that horse's share of the purse money. So that affects the owner, and an administrative fine for the trainer. There are a number of enumerated mitigating and aggravating factors that appear in the regulation. Of course, the stewards and judges are not bound to consider only those, but there are some that they must consider. And then they adjust the fine or the penalty in accordance.
And have all of our 10 been in the minor category?
They have.
Sure.
Yeah.
Great. Thank you.
Thank you.
A couple of administrative matters. I need to correct first an error that I read into the record during the 71st public meeting. I did read into the record a list of additional simulcast outlets approved to receive the export signal from Suffolk Downs, and in that list we identified Monarch Management as one of those outlets. This name appeared in error and should be replaced with Saddlebrook Jockey Club. Monarch Management acts as an agent for that outlet, so I just wanted to correct that for the record. We received a request from Suffolk to simulcast the Hambletonian card from the Meadowlands. It's on Saturday, August 3rd. Pursuant to the authority delegated to me by this commission, we did conditionally approve this request. Our simulcast statute places a rather complex set of restrictions and conditions on the receipt of the various signals for simulcast wagering, and so the applicable conditions for this request were noted in that letter. Lists of racing officials. So both of our 128A live racing licensees submitted a list of racing officials to be approved by the commission. The approval had been given as the names had been submitted on a conditional basis pending successful completion of a background check. I'm happy to report today that all of those background checks have been completed on all of the officials, both the initial list, and we've had some supplemental names come in as the meets have continued. So that process is complete. And I have a few upcoming events just to notify the commission about. One is that the National Thoroughbred Racing Association's Safety and Integrity Alliance will be in town August 6th and 7th. This will be for the reaccreditation of Suffolk Downs. The accreditation team inspects all areas of operation from veterinary practices and drug testing to wagering security, aftercare of equine athletes, health and safety of jockeys, access to substance abuse and other support programs for backstretch workers and other occupational licensees. Suffolk was first accredited in 2011. The accreditation lasts 2 years. It's a 2-day on-site team that comes, so we look forward to welcoming them to town. And I don't want Suffolk to get all the love today, so I've got some news for Plainridge. Plainridge Racecourse is about to start its annual series Community Challenge. That's on Saturdays in August. Plainridge offers a series of races where individuals from various community organizations get to compete against each other in a series of special exhibition races. 2 winners each Saturday compete in a semifinal and then a final event, and all of the proceeds go to designated local charities. We are meeting with stakeholders over the next couple of weeks to complete our red line version of proposed changes to 205 CMR 6 and 7, which are the regs governing parimutuel and simulcast wagering. This is a pretty dynamic area in the industry right now, so I'm also going to be meeting with some of my cohorts from other jurisdictions in Saratoga next week, where the commission will be represented by at least one commissioner and some staff at the Racing Commissioners International Conference on Monday and Tuesday.
Great. How was the woman jockey that was in the hospital?
She is home. She's home and she's rehabilitating.
And she'll be riding again? There's no...
Anytime a rider goes down, the first goal that they have is to get back in the
Get back
saddle.
up.
Yeah.
Right.
Yeah.
Yeah, good. There was a note in the minutes earlier today about talking to DOR about the tax issue, and you were going to see if you could get somebody to come and speak to us.
I believe that's scheduled for the 29th.
Oh, it is, okay.
Yep.
Great.
That's good.
Great. 29th.
Monday?
The DOR folks, a couple of their staff plus their general counsel will be coming to our office on the 29th to discuss it with us first, and then we can determine what's the best way to present it to the commission as
Okay.
a whole and when to do that.
Okay, great.
Thank you.
Great. Anything else?
That would conclude the racing report. Director Day seems to have something. Thought I did. I think we're okay.
Anybody else? Questions?
No, I think this is another good report. I think that we're making great strides in the racing end of this, and it's
Yeah.
exciting to watch, as it is exciting to watch all of the things that are unfolding here. So, thank you.
I would call the attention of our media friends who are here or watching that, what's going on in the racing division in Massachusetts is staggering. The amount of change that's been made, where we've gone from being pretty much a laggard in most standards to being a leader in most standards is really remarkable. And, it'd be nice if somebody paid some attention to it, because you all have done a great job, and the folks from Plainridge and the folks from Suffolk Downs have really put their shoulders to the wheel and collaborated with us and totally changed the nature of our racing industry in a very short time, which is terrific. So congratulations to all of you. Thank you. Great.
Okay.
We have nothing else formally on the agenda for our regular public meeting. Does anybody else have anything that we hadn't anticipated coming up? Then I will take a motion to adjourn this meeting. So moved?
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Opposed? The ayes have it unanimously. That meeting is adjourned. We will take a few minutes break here while we rejigger some of the logistics, and let's see if we can start back at 10:15, 10 minutes. Are you ready to go? All right.
Just basically call.
All right, we are ready to go. If everybody would like to take their
You're gonna
seats.
introduce these guys.
Okay.
The guys behind us, our excellent consulting team.
All smushed in here.
We'll now be starting on the suitability hearing. Because this is an adjudicatory hearing, we will be conducting this a little bit more formally than we do our other regular public meetings. So I will be reading from a script for a good part of this, just to make sure that we're doing this right. Good morning. This is Thursday, July 25th, 2013. This is a Phase 1 suitability hearing before the Massachusetts Gaming Commission relative to the application of Our Way Realty LLC. My name is Steve Crosby, and I'm the chair of the Mass Gaming Commission. I'm joined I'm joined today by Commissioners Cameron, McHugh, Zuniga, and Stebbins. The entire commission will preside over the hearing and decision of this matter. This is an adjudicatory proceeding which is convened in accordance with 205 CMR 115.04, paragraph 3, and will be conducted pursuant to the formal rules outlined in 801 CMR 1.01, subject to the clarifications contained in 205 CMR 101.03 and Chapter 30A of the General Laws. Before we begin this process, I'd like to explain the procedural history that led us here, as well as the process that will govern this proceeding. Our Way Realty LLC submitted a Phase 1 application to the Commission. The Commission then instructed our Investigations and Enforcement Bureau to commence an investigation into the suitability of the applicant to hold a gaming license in Massachusetts. The Bureau has conducted such an investigation into the qualifications and suitability of the applicant and its qualifiers and generated an investigative report of its findings, which it submitted to the Commission. A copy of that investigative report was provided to the applicant by the Commission. Based on the report, the Commission has scheduled this proceeding on its own initiative. I see that a number of lawyers are present with us here today on behalf both of the applicant and of the Bureau. Before I go further, I'd like to ask each of you to identify yourselves and advise the Commission whom you represent. Why don't we start with the applicant side?
Thank you, Mr. Chairman and members of the Commission. My name is Dean Richland. With me is Kevin Conroy and also my colleague Jesse Alderman. All of us are from the firm of Foley Hoag.
And you represent?
And we represent the applicant and the qualifiers who are part of that application and still associated with our way.
And from the representing the Bureau?
Yes. Good morning, Mr. Chairman, Commissioners. My name is David Mackey from the firm of Anderson Krieger. With me is Steve Anderson, also at Anderson Krieger, and we will be representing the Investigations and Enforcement Bureau this morning.
Thank you. At the conclusion of my opening, did we miss counsel?
I'm Michael and Carroll, on the Michael and Carroll IEB consultant team, Bob Carroll, Michael Bohr, behind me is Bernard Murphy, and Bessie Sacco.
Thank you. Great. At the conclusion of my opening comments, we will address a preliminary matter involving the withdrawal of a qualifier to this applicant. Once that issue is addressed, this suitability proceeding will commence with a recitation and explanation of the investigative report by the Bureau. We will ask that the Bureau outline the manner in which the investigation was conducted and outline the findings relative to each qualifier. The Bureau's presentation will largely be made by Director Karen Wells. Director Wells is joined by the consultants from Michael and Carroll, whom you've just met, who assisted in the conduct of the investigation. We will allow the consultants to offer any clarification or answer any questions during Director Wells' presentation. Any commissioner may ask a question of Director Wells or a consultant at any point during or following her presentation. At the conclusion of the Bureau's presentation, the applicant, through its counsel, will be afforded an opportunity to cross-examine Director Wells or a consultant relative to any information contained in the investigative report or to which they testified. The applicant may also reserve its right to cross-examine until the end of their own presentation if they so choose. Next, the applicant will be given an opportunity to present its case. The burden in this law is on the applicant to demonstrate by clear and convincing evidence both its affirmative qualification for licensure and the absence of any disqualification for licensure. To that end, the applicant has already subjected itself to a thorough background investigation, the results of which are set out in the investigative report. Those findings will be considered in determining whether the burden of clear and convincing evidence has been satisfied. For purposes of this proceeding, however, the applicant may call any witnesses and present any other evidence it desires in an effort to satisfy its burden. The Commission has directed that, at a minimum, John Grogan and Timothy Peterson present testimony as to the issues set forth in the notice of this hearing that was provided to the applicant. I understand that counsel for the applicant has had an opportunity to meet with counsel for the Bureau and the Commission to discuss this proceeding. The purpose in part was to clarify some of the issues that the applicant should address in its presentation. Those are primarily the issues that are set forth in the written notice of this hearing. Is that correct, applicant, that has transpired?
That is correct, Mr. Chairman.
While those areas should be included in the applicant's presentation, it may certainly address any other issues it believes may be relevant to its suitability determination. Similarly, the commissioners may certainly inquire into any issue that is of interest to us. At the conclusion of each witness's direct testimony, counsel for the Bureau will be provided an opportunity to conduct cross-examination of that witness. Then each commissioner will be afforded an opportunity to ask questions of the witness. Any commissioner may, however, ask any question of any witness at any time during an examination or at the conclusion of the examinations. We will allow a very limited redirect and recross of a witness if it is absolutely necessary at the end of the process. Either party may raise any objective they desire at any time. However, the basis for all objections must be clearly stated. Finally, at the conclusion of all the evidence, the applicant will be provided an opportunity to make a closing statement summing up why it believes that it is suitable to be issued a gaming license and should be allowed to proceed to the Phase 2 portion of the application process. Before we begin, I understand that there are a number of pre-marked exhibits that have been provided to the applicant in advance. Is that correct?
That's correct.
Are there any objections to these exhibits being marked and entered into evidence?
There are no objections.
Yes, Mr. Chairman, we have the 4 exhibits that were marked previous to today's hearing, and there's no objection from Mr. Richland, as I understand. And we've added a 5th exhibit as well with Mr. Richland's concurrence.
And those exhibits are, briefly?
The 4 exhibits are, Exhibit 1 is the 3-page notice of this hearing. Exhibit 2 is the cover letter dated July 3rd, 2013 from Director Wells to the Commission. Exhibit 3 is the 9-page executive summary related to the qualifications of Our Way Realty LLC. Exhibit 4 is a redacted copy of the 85-page investigative report prepared by the Bureau, and we have added a 5th exhibit again with the agreement of counsel for the applicant, which is a February 7th, 2012 fax letter to Mr. Fulton and Mr. Ross from a gentleman named James Oslin, O-S-L-I-N, CPA at the firm of Gosul, Butkus, and Jessen, LLP, and I have additional copies of that document for the commission.
Yeah, I don't think we've seen that.
I don't think we've seen that.
exhibit.
I'll have a copy.
The redacted version of the investigative report is available on our website for those of you who are interested. Thank you.
We have, with respect to exhibit number 5 that I just handed out, made a minor redaction to make the redactions consistent with the redactions that are contained in the report itself.
Okay, we'll just take 1 second so we can read this. Tell me when you're all, everybody all set with that? Commissioner Stebbins?
Well,
You ready?
I have a question relative to the exhibit numbers.
Yeah.
Are the 5 exhibits that you just outlined exhibits for the IEB, and there's additional
Yes.
exhibits from the
Yes, sir.
applicant?
There may-
As I understand it,
there
the
may be-
applicant has.
That's right.
There may be exhibits from the
Okay.
If I may address that, Mr. Chairman, consistent with the convention that council discussed at its pre-hearing conference, we have marked and presented exhibits as well Initially, we presented 2 exhibits, and I understand that this is, all these processes are new. Regrettably, we numbered them numerically, so they also bear numbers 1 and 2, although they are marked our way/applicant's exhibit. And so those have been pre-marked. There is a 3rd exhibit, which I think we're just about to discuss relative to Mr. Peterson.
And you'll present those exhibits at some point later
Yes.
on? Yeah, okay. Anything else, Mr. Mackey? about-
No, sir.
Okay. Are there objections to these exhibits being marked and entered into evidence? I gather there are none.
There are none.
Right. If either party plans on using any additional document above and beyond the exhibits that you've already referred to, I'd ask that it at least be noted for identification. If you were to use something to refresh a memory of a witness or something like that, at least be noted for identification if it is not ultimately introduced into evidence. Okay?
Mr. Chairman, if I might make an inquiry, one of the concerns, which I know the Commission has as well, is about confidentiality, particularly around proprietary issues. One of the reasons that there are not more exhibits is because of that concern, and I wonder if you could simply address whether documents that may be marked for identification only will become part of the public record.
Well, let me,
Wait,
go ahead. Can you speak to this?
I can respond to that, Mr. Chairman of the Commissioners. There are 2 or 3 documents that I have shared with Mr. Richland in advance of the of this morning's proceeding, which I do not intend to introduce into evidence, but which I wanted, just is a matter of courtesy to Mr. Richland and his witnesses, to have before them, so that when I'm referring in my questioning to a particular document, they at least know what I'm talking about. It may be used, it may refresh their recollection. It may just simply orient them in terms of what exactly it is I'm questioning about. I had not intended to mark those as exhibits or introduce them into evidence, but if that's the Commission's preference, we can do that. I do want to be mindful of the confidentiality issues that were raised by Mr. Richland out of fairness to the applicant.
Mr. Chairman, if I could just be heard further on this issue. Typically, I think about marking exhibits for identification in order to protect the record should those exhibits be not admitted into evidence. I think Mr. Mackey and I are talking about the use of exhibits or use of documents in ways that don't reflect our wish to put them into the record. And so, although I understand the Commission's interest in the interest of knowing what was discussed at a hearing, is to have those kinds of documents marked for identification, I would ask that we not mark them for identification unless either side decides to move them into the record. Simply because I think that all these issues are new. The public record consequences, unfortunately, there's not a big body of experience regarding that. And so I would suggest that rather than mark the kind of documents that Mr. Mackey has described, we simply allow counsel to use them, and then if either counsel or the other side wants to move them into the record, that we then take up the issue.
And I have no objection to
Okay, right, that's fine.
May I ask a question? If we follow that procedure, then does the record consist solely of the verbal references to the document, or does the record include the document itself?
It includes only the verbal references. Again, Commissioner McHugh, my experience would say that there might be evidentiary objections in a court of law to the use of a document in that way.
No, I understand
Yeah.
that distinction, but I just want that to be clear. That,
Yes.
that insofar as the Commission's consideration is concerned, the verbal references alone are the uses to which the document may be put.
Correct.
All right.
And I just would remind people that, not so much the lawyers, but the rest of the folks watching, that this is an adjudicatory hearing, not subject to the public record laws in the same way as our traditional public meetings are. As you say, this is a evolving area of law, and there's a lot of uncertainty, but this is not subject to the customary open meeting constraints on availability, public accessibility of documents. Okay, you all right with that? The Commission anticipates that its inquiry at this proceeding will be limited to the matters addressed in the report. In the event that a line of questioning conducted by the Commission or Bureau moves into an area that has not been included in the reports, but that is included in part of the investigative file and is material to the suitability determination, the applicant may request a recess in the proceeding so as to review the issue. This request would be an unlikely happenstance, however, as the Commission anticipates addressing solely those issues covered in the investigative report. No final decisions will be made here today. That's something important for everybody to understand. The matter will be taken under advisement at the conclusion of the proceeding by the Commission, and after private deliberations, a written decision will be issued. If at any point during the Commission's deliberations it determines that further testimonial or documentary evidence is desirable, it reserves the right to ask the applicant to provide such evidence prior to a suitability decision being made. We will now swear all of the witnesses in. Anyone who will be testifying at this proceeding, please stand and raise your right hand. Do you solemnly swear that the testimony you will provide before the Commission at this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
All? Thank you. All have responded in the affirmative. Let's now turn to the matter involving the withdrawal of the qualifier. The Commission has before it a petition filed by the applicant for the withdrawal of qualifier Peterson. Generally, the regulations allow for withdrawal requests to be allowed as a matter of course. However, once a hearing like this suitability proceeding has been scheduled, the qualifier by our rules may only withdraw with the approval of the Commission upon the finding of good cause. I'd like to ask the applicant's counsel to present and address this petition.
Thank you, Mr. Chairman. As you know, pursuant to 205 CMR 11105, we have, that is, our way submitted a notice of request of withdrawal regarding Mr. Timothy Peterson. We think and believe and hope you agree that there is good cause shown for approving that withdrawal. As laid out in a letter that I sent to the Commission yesterday, and which has been at the direction of the attorneys for the Commission, been marked as an exhibit. That exhibit has been given to the stenographer, and copies have also been given to counsel, and I believe you have a copy of the letter. The letter has been marked as Our Way Applicants Exhibit 3. And in that letter, I described the events that have occurred over the last 48 hours. In particular, and not included in the letter, but some just additional information. I met with Mr. Peterson on Monday the 22nd to prepare for this hearing in furtherance of the notice of hearing that the Commission issued indicating that it wanted to hear from Mr. Peterson. When that session was over, I had every expectation that he would be appearing today. About 24 hours later, on Tuesday the 23rd, I received a call from an individual who identified himself as Mr. Peterson's lawyer and indicated that Mr. Peterson was resigning his position, and also further said that if Our Way believed there was value in him, in retaining him as an employee, that he would remain only if he received a contract for a one-year term. I reported this information to Mr. Grogan. There was some consultation within Our Way about this request. I will tell you, and as I indicated in my letter, it was apparent to me there was discomfort about considering any contract for a term or providing any additional benefit to Mr. Peterson on the eve of this hearing. There was no, before receiving this, there was no consideration, certainly no discussion with Mr. Peterson that his employment would not continue. So this came as a surprise. But the decision was made by Arroway, and I was asked to communicate to council that there would be no contract, that we would accept his resignation if that's what he was doing, but that we still expected him to appear at this hearing. I reported that conversation to counsel for the commission soon after that conversation. The chronology is then detailed further in my letter, but there was a request by commission attorneys to speak directly to counsel for Mr. Peterson. I certainly had no objection. They did ask me to speak to him in advance of that to see if I could persuade, again, Mr. Peterson to appear today. I could not. Counsel offered to speak to commission attorneys. I know that they did have a conversation with him, and as indicated in my letter, I did receive a voicemail at the end of the day on Tuesday from counsel confirming his conversation with commission attorneys and further confirming that he would advise his client not to appear today. Now, that is by way of background to the events. I don't see Mr. Peterson here today to speak to this request for withdrawal. In the absence of him making that request to this commission, Arroway thought it was imperative that it make the request. And the basis for that is simply this. It is Arroway's understanding that Mr. Peterson stood as a qualifier based on the title he bore. And he bore that title as a result of his employment with Arroway. The title he bore was CFO, Chief Financial Officer. As you know from review of the investigative report, although he bore that title, he readily acknowledged that that was not a role that he discharged for the organization. And again, evident in the report are subsidiary facts which bear this out. Primarily, that he did not feel it was his place to have any direct reporting relationship with the members of Arroway, which would be common for a CFO to have a direct channel of communication with members of the board of a corporation or members of an LLC. So upon his resignation and the cessation of his employment, it seems to Arroway that there is now no basis for him to serve as a qualifier on this application. And given that he's not here to offer testimony as requested by the commission or to offer testimony in support of this motion of withdrawal, in addition, those reasons in addition, we think constitute good cause to approve this withdrawal and remove his name from the application.
Commissioners?
Mr. Richland, I find that problematic. I think that this qualifier was the only person left as a qualifier with firsthand knowledge of the activities at the track, and that's critical information for us to move forward. I find that to be problematic, that he's not here, and there's really no further explanation as to why he's not here.
I understand the position that you've articulated, and I want to assure you, in the strongest terms I can use, that it is Arroway's preference, and it has been Arroway's preference, and it was Arroway's intent that he be here. So that's the first point. Second point.
If you had agreed to hire him for a year, he would be here.
That's right, and we would need to disclose to you the circumstances under which we entered into that contract, which frankly, again, I have no basis to believe that to know what his motivations or counsel's motivations were in requesting that kind of job security. But given the timing and the circumstances, and the interest of projecting for you and giving meaning to the words that this is a new organization in terms of its internal controls and governance, a new organization in terms of its commitment to integrity, to be providing a benefit to a critical witness that you want to see on the eve of trial was frankly seen as distasteful to the organization and would undermine exactly what the organization has been working to achieve since April. But that's point one. The second point about the issue of speaking to those past events, which again, I appreciate, and we're prepared to do that as best we can. I do note that in the Investigative Bureau's commission report, that one of their concerns that they expressed was the fact that some people who had an involvement with some past investigations and events that will be the subject of today's hearings had an ongoing role. That was expressed as not as a positive, as we read it, but as a negative. In other words, continuing ties to the way things were done. As I mentioned, it was clear that Mr. Peterson was not acting as a CFO. What was also communicated to him, and I will disclose this because he got a copy of the unredacted report, so this is not news to him, is that he would not have been considered for the CFO position on the assumption that a gaming license is granted. So we can speak to those events, but the fact that, and he could have spoken to them as well, whether he was an employee or not, but the fact that he's not an employee, we think, means that there's no basis to consider him a qualifier. The issue of his testimony and his appearance, frankly, informs a decision about whether he should be a qualifier. But it is a separate issue. It is a separate issue. The key issue about qualification is whether he's still employed. And by any stretch, this was a voluntary and sudden decision on his part.
I understand your concern about the appearance of bias if the contract were granted in accordance with his request. At the same time, he is potentially a key link in the discovery of whether this truly is a new organization. He is a person at the apex of a number of historical facts and strands of behavior. And it seems to me that his testimony is critical. And it seems to me that the determination of this commission as to whether he personally is qualified, apart from the qualifications of our way, is particularly important under the circumstances you've just described. One of the reasons that permissive withdrawal only rule was it was inserted into the regs was to avoid precisely this kind of a situation with respect both to entities and individuals. Mr. Peterson's been in this regulated industry in one of its incarnations or others for years. And it seems to me, as a single commissioner, important that the commission follow through on this in the only way that it can, in precisely the way the regulations envisioned. And that is through a statement about qualifications of the individual. As I say, regardless of what the ultimate determination is regarding the entity. So I say that so that you have an opportunity to respond to that. I'm thinking out loud a bit with you, and it is, of course, only the statement of one commission.
I appreciate that, Mr. Commissioner. and I understand I understand the fact that an option before you is to keep him in that position so that you can issue such a statement. And if that is the decision of the commission, although that's not our favored path, then we would simply request that there be a separate ruling relative to his suitability apart from our way and the other qualifiers. Once he hired separate counsel, and once he was no longer an employee, as a matter of fact and law, our way lost the ability to produce him as a witness. And so that's where we are. And while I understand the interest in speaking to him and the importance of him serving as a link, I do want to say that, and you're about to hear from Director Wells, and you know this from a very comprehensive report you have before you, that it's not as though there is not evidence already on the record and evidence that supports what's on the record. He was interviewed under oath. The facts and circumstances that he spoke to, others were questioned about. Documents were gathered and reviewed, and so there is a record, but I understand that it would be important, and as I say, our preference, that he would appear so you could gauge his credibility and assess that in connection with some of the answers that he gave. That would be our preference, but it still is our preference that his application be withdrawn, but I do understand the option, and if that's the option the Commission pursues, I do request that a separate decision be made relative to his suitability.
Other comments or questions? Do our council have anything they want to add to this conversation?
Mr. Chairman, I don't think the Bureau has a specific position with respect to the petition to withdraw, though I think Director Wells would like to speak to the effect of the attempt to withdraw on the potential suitability of the applicant.
Thank you. Good morning, Mr.
Morning.
Chairman, members of the Commission. Before beginning my summary presentation of the report findings, I do think it's appropriate as the Director of the IEB that I comment about the abrupt withdrawal of Timothy Peterson from the application. I find it extremely troubling that Peterson is not here present this morning, despite the directive from the Commission that he be here to answer questions. As an investigator, that raises grievous concerns in my mind as to the reasoning behind the abrupt departure 48 hours before the hearing. It is certainly appropriate for the IEB and the Commission to make negative inferences as a result of this change in circumstances. I am particularly concerned that he is not present to address questions regarding the money room practices of Gary Pankowski, including questions regarding who knew what and when they knew it. For example, as detailed in the report, there is some question as to Mr. Fulton's knowledge of the practice, and Peterson would be an important witness as to the letters from the outside auditor. As the Commission is aware, the IEB did not recommend an unconditional finding of suitability. The applicant was required to come in and participate in this adjudicatory hearing. The basis for this hearing is the investigative report concerns over business practices of the applicant, and now the CFO is not present to address those concerns. This latest development calls into question what is going on behind the scenes here, particularly in light of the similarly abrupt departure of Gary Pankowski from the application. As we've stated numerous times in public meetings, determination of suitability is an ongoing process, and obviously this additional development should impact the ultimate finding. Thank you.
Any other comments?
If I could just briefly respond to some of the points that Director Wells made. Again, we understand that this is unsettling to the Commission and the IEB. It is unsettling to the applicant. As soon as we heard from counsel, literally within minutes, the information was communicated to counsel for both the commission and the IEB. At the same time, a offer was made to address any questions and at any time between then and now. And that offer included me and Mr. Grogan, so that any questions that the IIB wanted to have answered in advance of today, and we understand and are prepared to address any questions you have in the context of the application about this departure. Mr. Grogan will speak to that and welcomes the opportunity to do so. But I simply make this point so that to underscore that from Arroway's perspective, given this sudden change, it did everything it could to address it in a responsible way, and to try to deal with the absence that would be caused by his non-appearance. We did everything we could, short of agreeing to a contract for a term under the alternative that he was going to resign 2 days before this hearing. Short of that. And as to that, Mr. Grogan is very ready to testify as to why that was not seen in his view, or those with whom he consulted, as a appropriate choice or a real choice. So I do want to speak to that. And the second thing I do want to say, the issue of an inference, I understand that as well. And certainly at this point, Mr. Peterson is not an agent or representative of Arroway. As soon as he resigned, he ceased becoming an agent. And whether, in fact, you might find him to be the CFO, other than that he bore the title, so that there is some consequence for what he says as it affects Arroway, that doesn't exist anymore. And unless you find, and I dare say you won't find any basis to conclude that Arroway was responsible for his non-appearance, then I think there's no basis from his non-appearance alone to infer anything adverse to Arroway. Obviously, you'll hear the evidence, you'll consider it, but I do believe that's what the evidence will show. Under those circumstances, an inference may be drawn as to Mr. Peterson, but I do not believe an inference can be drawn as to Arroway.
Isn't his termination of his agency relationship itself the act of an agent? It's metaphysical, perhaps, but isn't that so?
I would suggest not. I would suggest that is a personal and not a representative act at that moment. And
Does that depend on the agent's motivation?
Well, it may, but I think that even assuming a motivation that was in the nature of a whistleblowing motivation, that given some of the other ways to communicate that, I think the use of the resignation would not constitute the admission. And even in a whistleblowing, I don't think that a whistleblower's communication is then chargeable to the entity for whom he works. In other words, that may be evidence of wrongdoing, but it's not as though it's an admission of wrongdoing by the applicant.
Well, I don't want to speculate on motivations.
Nor can we.
Because if you start down that path, there's a whole bunch of them there that one could think about.
Other commissioners?
I have a question perhaps for us or for our council. Do we need to resolve these requests before we can continue the proceedings?
No, I don't.
Our expectation is that we will not, that we will take it under advisement and deal with it at the same time as we deal with the suitability.
Oh, our expectation for this is that?
Is that we would not to make this decision right at the moment. That's nothing cast in stone about that. If you feel differently, we can talk about that. But in talking with council, we had established a sort of a presumption that we would not deliberate on this and decide it now. We would roll it into the deliberation on the suitability. But I'm totally happy to discuss that. There are two issues. One is the permissibility of the withdrawal of Mr. Peterson and the suitability of our way. And we want to try to keep them separate as much as we can, although clearly they connect. But if Mr. Grogan has comments about the withdrawal of Mr. Peterson, the whys and the wherefores, the why, what his reactions were, what our ways are, does seem to me that that's an appropriate testimony to hear now.
Okay.
So, do you disagree with that?
Could I? No, that's fine. But I am not, as one commissioner, am not convinced that the two are separate. Although, as I said to Mr. Richland, I think we have to make separate ruling. The ruling on the withdrawal does not necessarily create a force that drives the ruling on our way. But I don't agree that they necessarily are two separate things. I just want to be precise about it.
I agree. If I said something different, then I totally agree with you. I accept that characterization. So, Mr. Grogan, do you want to speak to this, to the issue of the withdrawal and its relationships to everything else that's going on here?
Thank you, Chairman Crosby, Commissioners, good morning. At some level, it seems to be a bit odd to be having a discussion about the resignation of a CFO having come from council rather than coming from the president of the company. And in fact, as we talked about that, the reason for that is Mr. Peterson resigned through his council, through our council. So we, in fact, had finished a staff meeting on, now I believe on Tuesday, at which point I got a call from Mr. Richland explaining that Mr. Peterson had resigned.
Was he at your staff meeting?
He was not at our staff meeting. So from the time he had been on vacation last week, met with Mr. Richland Monday morning, and I had not seen him since that time. So the first thing I heard was he was resigning when I got the call from council. Needless to say, I was greatly surprised. Then had a conversation. In fact, in that meeting, our chairman, Al Ross, was there, had a conversation with Al about this as it was described to me. He was resigning. However, that if there were a one-year employment agreement, he would consider staying. It felt at the time coercive. And I would point out, if we had done that, that would be the only employment agreement in the company. I do not have one. And on its face, it would appear wrong. As you know, and as council testified, in terms of what Mr. Peterson's role within the company and what we saw going forward was clear. And while seemingly odd from a timing perspective, you can infer no inference of there was something else that was known. It was a total surprise. We expected Mr. Peterson to come talk about what was in the report. Again, earlier, Commissioner, you made a question about could he testify to the change that's going on? I hope, and I will later talk about what is happening, what we're doing, and the changes that are being made. And I don't think that his departure and his choice to leave reflects on that. But I do understand and appreciate how it looks, but it was stunning, surprising.
Okay.
Mr. Chairman, if I might,
Move the mic.
understand.
Move the mic.
Excuse me. And we've listening to the conversation and understanding that Mr. Peterson's absence here today leaves something of a hole. And I've not discussed this with the applicant, but one, opportunity here might be his sworn we have a sworn interview for him, which has not been marked into evidence, and there may be some confidentiality issues associated with that. But if it were the commission's desire, we could have a discussion with the applicant and the applicant's counsel about the introduction into evidence of pieces of that sworn testimony, if that would be helpful. Presumably with reserving a right to at least attempt to bring him back to answer questions if the commission had further questions upon review of that testimony.
Well, as I understand, we have access to that. That is part of the investigative file. It is something that we may bring into consideration in our deliberations. If so, we will make it clear that that was a part of our deliberations, not just the investigative report. I don't know that it's necessary to put it on the record now as an exhibit, but we have access to it. We know about it. We can use it if we feel we want to. I don't know that it adds anything to be added as an exhibit at the moment, but I defer to others if you disagree.
Well, it's precisely that interview that I had many, many questions about. There were many areas that were not fully explored as far as his answers to questions. So I get back to, why he's not here, and you can't give us that answer why he's not here, and that's critical to what we're doing here.
I think that it should, Mr. Chairman, be marked as an exhibit under all of the circumstances after consultation with counsel. I don't think, as one commissioner speaking, that it's a substitute for his appearance, but I do think it's an important piece of material for the commission's consideration in making its ultimate judgment. So I would request through you, if it's consistent with the wishes of the commission, that Counsel Mackey engage in conversations with Counsel Richland and come up with some agreed upon mechanism for marking that as an exhibit, so that it is clearly part of the record of these proceedings.
Just from my edification, what is the difference between its being an exhibit and it's being brought into our conversations and made part of the record subsequent to this?
That if we bring something into our conversations later, if indeed we can do that, and under the circumstances we do it, we need to give people notice that we've done it so that they have an opportunity either to object to our doing it or an opportunity to respond to things in it that they think need response. And if we do it in this fashion up front, everybody's on notice as to what it is.
So Mr. Mackey and counsel would discuss it today, you're talking about?
Or discuss it today, and then the questions could be addressed if they wanted to during the course of the proceedings. If they wanted to defer discussion until later, they could do that as well. But they should. I would request that they take the first crack at that, and that it be formally marked as an exhibit.
That's fine with me. Everybody okay with that? We'll probably have a lunch break where maybe that can be discussed, or you can deputize a team, or however you want to do that. And then once that's resolved, and it is, as soon as it is in, whether that's today or whenever, let us know what the implications of that are and how it works.
Mr. Chairman, first of all, I just want to let you know that is completely acceptable to the applicant. And the second thing, I would simply also remind you that the commission does have subpoena power. While I don't know whether Mr. Peterson is within the subpoena power, you do have it. And it seems to me that you could make a determination to hold a session, see if he appears, and then subject him to the questions you have.
We're aware of that.
He lives in Rhode Island, doesn't he?
That's our information.
Right.
Okay, are there anything else about the issue of the withdrawal of Mr. Peterson? Mr. Restev?
Just, I guess, one question for clarification. In the letter, counsel, that you mark as your own applicant exhibit, 3, he would remain only if he received a contract of employment for a 1-year term. Was that a contract of employment in the position that he currently held? Was that detailed that way?
That was not detailed out, and so I'm reporting what I heard. I did not ask the question as to what position that would be a contract for. My own impression was that that was an open issue, but nevertheless, what was significant to me and I think to Arroway was the contract for a term.
Okay, if we do get this in as an exhibit, we can come back to this topic. It's clearly directly relevant to the suitability issue, even more probably than to the issue of the withdrawal. So it's appropriate to bring this up later on in the discussion, once we get determined whether or not it's an exhibit. If there are no other preliminary issues or objections for proceeding from applicant's counsel, I will ask Attorney Mackey to begin the Bureau's presentation on the suitability of Arway Realty LLC to be an applicant for a license in Massachusetts.
Yes, sir. Thank you, Mr. Chairman, members of the commission. Good morning again. At this point, without any further ado, I am going to ask Director Wells, the Director of the Investigations and Enforcement Bureau, to summarize for the commission the June 18th, 2013 suitability report on Arway Realty, and she could proceed.
Okay, thank you very much. Good morning again. As a preliminary matter, I just want to thank the consulting firm of Michael and Carroll for all their hard work on this project. Guy Michael and Robert Carroll are the principals for that entity, and they have done outstanding work, and I would like to commend them on both their integrity and their performance. And as the commission is aware, this investigation was conducted in conjunction with the members of the Massachusetts State Police assigned to the Investigation and Enforcement Bureau. We are very fortunate to have a group of first-rate troopers assigned to the office with extensive investigative experience who did an outstanding job on this and our other investigations, and I would like to publicly thank them as well. I'd like to refer back to our prior meetings where I have in fact publicly gone over the investigative process that the consultants and the IEB have undergone for all these applicants. Because it was such an extensive presentation, I won't reiterate the details of the process, but I'll just refer back to the presentation I've done before, and that the investigation in this case into this applicant followed that same procedure. Arway Realty LLC has applied for a Category 2, a slots license. The applicant has plans to construct a slots parlor at Plainridge Racecourse. That's located at 301 Washington Street, Plainville, Massachusetts. The investigation confirmed that the company does hold the title to the property. Arway was established as a domestic Massachusetts limited liability company in February of 2000 for the purposes of acquiring ownership of the Plainridge Racecourse in Plainville, Mass. I will note that this Plainville is the only remaining harness racetrack in the Commonwealth. Arway is owned by a small group of investors, with the two largest investors being Stanley Fulton and Alfred Ross. 3 additional owners have also been deemed qualifiers. Those are George Chimento, Richard Took, and Fred Chanowski. The remaining owners were not deemed qualifiers based upon their very small ownership interests. None of the owners have been actively involved in the day-to-day management of the applicant's racetrack operation. For the most part, they have been passive investors. I was recently notified that Mr. Fulton would be the new CEO. This change took place after the completion of the report, and I expect that will be an element of the applicant's presentation. As of submission of the report, the applicant had not identified key operational employees who will be responsible for the proposed facility. The applicant advises that it is conducting searches for experienced gaming management. Just want to give the commission a little bit of financial history of the applicant. The investigation revealed that Arway has had steadily declining revenues and negative earnings and negative cash flow from operations. Our Way depends on cash infusions from its members to satisfy its obligations and thereafter is unable to repay those infusions, which are considered to be loans for which neither principal nor interest is paid. It is recognized, however, that declining revenues has been the fate of all racetracks in the Commonwealth. The financial viability of racetracks within the Commonwealth was in part an impetus for the passage of the Expanded Gaming Act. In terms of financial resources, the applicant ROA raises capital and borrows funds from its members and a related company, Anchor Partners. It has little to no third-party borrowings from financial institutions such as banks or other licensed lending institutions. Fulton and Ross are the sole members of Anchor Partners, which is the applicant's second largest financial source. Fulton is currently the applicant's largest financial source. In addition to having made contributions of capital, Fulton has lent and continues to lend significant amounts to Our Way. Aside from the amount lent to Our Way by Fulton to date, Fulton has committed in writing to lend that which is needed to fund the construction of Our Way's proposed Category 2 gaming facility. To date, Fulton has provided the financing necessary for construction of the parking garage at the Plainville Racecourse site. Fulton is a wealthy man having adequate assets to fund this project. Ross also has significant assets and is in a position to make additional contributions if required. If there are any new investors, vetting will be required. The projected estimate for this project is about $160 million total. It's broken down into $125 million for construction, $25 million for licensing fees, and $10 million for working capital and pre-operating expenses. Next, I'd like to give the Commission just an overview of the applicant's background. In March of 1999, Plainridge opened as a harness horse racing track in Massachusetts. Currently, live harness horse racing is offered from April through December each year. In addition to live harness horse racing, Plainridge provides for parimutuel betting on live simulcasting from various domestic and international racetracks offering harness, thoroughbred, and greyhound racing events. Our Way is currently the sole owner and operator of Plainridge and has held this Norfolk County harness racing license to operate Plainridge since 2004. This license was issued by the Massachusetts Racing Commission, which has now been operationally merged into the Massachusetts Gaming Commission. The investigation also confirmed that the former licensee and operator of Plainridge was the Plainville Racing Company, LLC, which held the license from 1999 through 2003. PRC, as it is known, is currently inactive. Ross was one of the initial investors in PRC, along with George Chimento, Richard Tuck, and Fred Chanowski, investors who have also been deemed individual qualifiers for this applicant. PRC was formed by Gary Pankowski in 1998 to apply for the Norfolk County Harness Racing license to operate Plainridge. Ross then sought out Fulton to solicit his interest in the venture around 1999 to 2000. Fulton agreed on behalf of Anchor Gaming to speculatively invest in anticipation of Massachusetts legalizing gaming at some point in the future. Anchor Partners was formed in March of 2000 to provide the financing to Our Way to purchase the property. PRC leased the racetrack from Our Way and held the racing license to operate Plainridge through the 2003 racing season. In 2004, Our Way applied for and was granted the license for the Norfolk County Harness Racing license to operate Plainridge, which continues to operate up until the present time. Mr. Fulton is also the founder and owner of Anchor Coin, which subsequently was acquired by Anchor Gaming, a publicly traded company, also founded by Fulton. Anchor Gaming was later acquired by IGT. Fulton has since sold all of his interest in Anchor Gaming and no longer has any affiliation with IGT. Fulton is also the owner of Sunland Park Racetrack and Casino in Sunland Park, New Mexico. Fulton acquired ownership of Sunland and is the sole beneficial holder of Sunland ownership interest. Mr. Ross has been involved in the parimutuel racing industry since 1941 when he began working for his uncle, who purchased and reopened Taunton Greyhound Park, at that time a defunct, non-functional racetrack. Ross eventually became an owner and operator of 3 dog tracks in Colorado, a dog and horse track in South Dakota, and held an ownership interest and operated Lincoln Downs in Rhode Island. Ross has since sold all his interest in those racetracks, having done so over 25 years ago in 1989. Our Way is currently the only racetrack in which Ross presently maintains any ownership interest. I'd like to note that from approximately 2004 through April 3rd of 2013, the management of control of Our Way operations was vested exclusively in Gary Pankowski. Pankowski was, for the last several years, the public face and voice of Plainridge and had been responsible for leading Our Way's pursuit of a Category 2 gaming license for Plainridge. He had been the president of Plainridge Racecourse since it first obtained a license in 1999. He was president of Plainridge during the time Plainridge Racing Company operated the racecourse, and also assumed this role when Our Way became the licensee and operator of Plainridge. Pankowski was also appointed manager of Our Way in July of 2008 after Took resigned from that position. Gary Pankowski was also became the manager of Anchor Partners in January of 2012 when Tuck resigned from that position. Prior to Pankowski's development of Plainridge Racecourse, our investigation confirmed that Pankowski was previously the chairman of the Massachusetts Racing Commission from 1991 to 1993. As the investigation commenced, it quickly focused on Gary Pankowski. During the years of Pankowski's leadership of Plainridge, numerous significant and reportable events occurred. The most concerning situation was his practice of withdrawing cash from the Plainridge Racetrack money room. During this investigation, it was learned that Pankowski routinely, almost on a daily basis, withdrew small amounts of cash from the Plainridge Racetrack money room. These direct cash withdrawals were recorded by Peterson as monies owed by Pankowski. When this money was not repaid, it was recharacterized at the end of each year as a distribution to Pankowski. Overall, the investigation confirmed that these yearly withdrawals amounted to a very large sum of money. These withdrawals have been described by some of the members of the applicant, as well as Mr. Grogan, as an accommodation to Pankowski. When questioned further in the current IEB investigation about these withdrawals, Mr. Peterson stated he did not feel that at the time of their occurrence it was his place to bring this practice to the attention of Our Way majority owners Ross or Fulton. Peterson indicated that Pankowski was the president and thus his supervisor, and he trusted that Pankowski had received the approval of Fulton and Ross. However, Peterson also advised investigators that in approximately 2006, and it may be that this actually occurred in 2008, I'll refer to that later in my presentation, and due to his concerns about the money room practices, Peterson requested that the Plainridge outside auditor prepare a letter each year having the annual withdrawals taken by Pankowski and request approval by the majority members, Fulton and Ross, to treat as a distribution to Pankowski. As part of this investigation, the outside auditor for the applicant was questioned concerning this annual money withdrawal letter. Peterson may have been mistaken with respect to the year when these annual money withdrawal letters actually began prepared by the outside auditor. The outside auditor indicated the first letter prepared was for calendar year 2008. Each year, these letters were submitted to Pankowski in his capacity as manager for Our Way. However, the outside auditor indicated that although these letters were submitted to Pankowski each year, it was not until February of 2012 when he actually received the letter back signed by Fulton and Ross. The February 2012 letter listed the advances made to Pankowski for calendar year 2011. The 2012 letter also now reported the previous advances made to Pankowski for calendar years 2004 through 2011. In a sworn interview, Fulton indicated he was unaware of these practices despite the letter having his signature. Shortly following Fulton's sworn interview with investigators, where he was informed and questioned about these money room practices, it was reported by the applicant that these money room withdrawals taken by Pankowski, which became the focus of questioning during the investigation, resulted in applicant internal discussions about the need for better internal controls and proper corporate governance. The resignation of Pankowski and the appointment of John Grogan as president then followed. During Ross's interview, he stated that he realized there was a need for better internal controls, and he also realized there had been too much control vested in Pankowski. Ross has stated that Grogan had been engaged by Pankowski in 2009 when the applicant began exploring the proposed expansion of his operation into gaming, and he was confident that Grogan would put immediate measures in place to improve the corporate governance and internal control environment of the applicant. Mr. Fulton stated that after his first interview with the IEB investigators, he immediately began to more closely review the job responsibilities and the business practices of Pankowski. In particular, the additional distributions Punkowski was receiving over and above his compensation and for cross-reference to the periodic money room withdrawals were now examined by Fulton. Although the investigation confirmed that such money room distributions did occur, it could not definitively confirm whether such distributions were knowingly approved by Fulton. In fact, in his first interview, Fulton denied having any recollection of having approved these distributions. Fulton stated that after his first investigational interview, he met with Grogan and other highly trusted business associates, and after reviewing the conduct of Punkowski, they decided it was not in the company's best interest to have Punkowski remain as the president of Arway. Earlier in this investigation, when questioned about the applicant's compliance plan and internal controls, Mr. Grogan reported that Arway operates a small harness racing business and not a full-blown gaming operation. As such, it was represented that Arway does not maintain a compliance committee and does not have a current compliance plan. It was further represented that all issues regarding compliance were elevated to and handled by former President Punkowski. Arway also reported had no formal anti-money laundering policy, and the applicant did report that consistent with applicable federal law, it does file the appropriate currency transaction reports, or CTRs, when transactions are $10,000 or greater. From our consultants' experience in the gaming industry, they are aware that some smaller non-casino operations do not always have thorough and effective compliance plans and/or functional committees. However, due to the various past investigations that evidenced questionable money room transactions and apparently limited ownership awareness of actual business practices being utilized at the Plainridge facility, the lack of an effective compliance and internal control structure represented a significant operational deficiency. As this investigation developed, additional information was requested by investigators with respect to internal control procedures. In this regard, during Peterson's sworn interview, he did indicate that money handling control procedures are in fact in place for the pari-mutuel window. Peterson explained various procedures in place which pari-mutuel clerks are required to follow with respect to the daily reconciliation and settlement of their windows, including procedures for opening, closing windows, turning in bankrolls, punching tickets, etc. When questioned why there were no written internal procedures for money room operations at Plainridge, Peterson stated there were only 4 people in the money room, 2 of which have 60 years of experience between them. Therefore, he did not feel it was necessary to document the processes that were in place. Peterson indicated if new employees were hired, it would be at that point he would feel it would be appropriate to institute written procedures. Peterson also stated that at one point he attempted to develop an employee handbook with policies and procedures, but President Punkowski was not supportive of such an effort. Peterson did convey at least a general awareness that the applicant was awarded a Category 2 gaming license. Substantial additional financial, internal control, and other industry standard money handling policies and procedures would need to be implemented and documented. More recently, during the latter part of the investigation and after Grogan's appointment, the investigative team was supplied with new documentation consisting of Arway's new written internal controls with respect to the Plainridge operation. Specifically, the new written internal controls with respect to the Plainridge operation, specifically new internal control standards implemented by the applicant involved enhanced controls over authorization, accountability, safekeeping, the use of paper document safeguards, electronic records, physical premise and employee safekeeping, and a more stringent human oversight and reporting requirements. The applicant also provided documentation evidencing a better defined internal administrative and organizational system with improved checks and balances. Example of the improvements include the separation of the positions of manager and president, the implementation of additional signature controls, petty cash approvals, personal expense reimbursement procedures, Arway manager approval for the president's expense account, 2 signature requirements for checks over certain amounts, prohibition of employee betting at the track, revising and refining pari-mutuel teller policies and procedures, and the development of a new employee personnel handbook. Mr. Grogan has also provided documents entitled Arway Realty Management Systems and Internal Plan, dated May 2, 2013, which provides for the creation of an advisory board. The investigation undertaken in this manner was not limited to only the qualifiers and the qualifying entities. In order to gain a better understanding of the owner Fulton's history of regulatory compliance in gaming and racetrack operational prowess, the investigators also contacted the New Mexico Gaming Control Board, as well as the New Mexico Alcohol and Gaming Division, with respect to the compliance record of Sunland, his casino there, which he owns in the entirety. This racetrack and slot machine facility is owned by Fulton through a holding company, My Way Holdings LLC. Although the applicant's representatives have indicated that Sunland management will not perform an active role in the management of Orway's proposed Massachusetts gaming facility, given Fulton's ownership of the Sunland facility and its similar size, scope, and nature to what is statutorily anticipated in the Commonwealth's Category 2 license award, the investigative team concluded it would be of assistance to the IEB to examine the regulatory record of Sunland. The investigation confirmed that Sunland received its New Mexico gaming license in 1999 and is licensed and regulated by the New Mexico Gaming Control Board. The acting executive director had confirmed that Fulton has been found suitable in connection with his ownership of Sunland. There have been certain gaming regulatory violations that have been documented in New Mexico concerning Sunland. However, these violations can be described as minor and typical of the type and frequency that is common in the casino gaming industry. During the last 5 years, 2 of the violations against Sunland involved having minors below the age of 21 on the casino floor. The first citation in January 2010 resulted in a payment of fine of $100. Second citation in 2010 result in a payment of fine of $1,000. Additionally, in June of 2011, Sunland was cited for having alcohol in the casino, which is prohibited by regulation. This resulted in a $1,000 fine. The investigation also revealed 2 charges brought against Sunland by the New Mexico Alcohol and Gaming Division in June of 2010 in connection with the sale of alcohol to minors. And this resulted in a $1,000 fine per incident and the suspension of alcohol sales for 2 separate days. In sum, those violations are of a like in kind not uncommon in the casino gaming industry in North America. In fact, according to our consultants, only 3 gaming-related violations and 2 alcohol-related violations of this type over a span of 5 years does not represent a pattern of non-compliance and/or disregard for gaming regulators or regulation. Equally important, these violations were self-reported by the gaming property manager to the regulatory agency and have been addressed with remedial actions. The 2 incidents of alcohol sales to a minor were a result of an undercover sting operation. Remedial action which was taken included the termination of the bartender and additional training to the property staff. Acting Executive Director Baca from New Mexico confirmed in writing Fulton had never been the subject of any kind of disciplinary action by the NMGCB, and has further confirmed that in the view of the NMGCB, Sunland is one of the better run and managed facilities in New Mexico, and that this casino has a long history of compliance and cooperation with that agency. The investigators also took a look at litigation history of the applicant and the qualifiers. The investigation has reviewed all document civil litigation for applicant and the entity qualifiers and has requested and been provided explanations by the applicant for each material and relevant action. The specific cases are identified in the report that you have before you. After review and evaluation of the matters in the applicant explanation and other relevant materials, with the exception of the litigation referred to in the report as the Giuliano litigation, those instances appear to be those that would be ordinarily expected in the course of a typical business. It is to be noted, however, that the Giuliano litigation also involved Plainville Racing Company, or PRC, the former licensee for the Plain Ridge Racecourse, and Punkowski. Although there were allegations of fraud and deceptive practices by both sides, the Giuliano litigation ultimately resolved in favor of the applicant and the other defendants. As such, litigation in which the applicant has been involved cannot be said to demonstrate conduct evidencing any unacceptable business practices on behalf of the applicant or any of the qualifiers. Going to the licensing and compliance history of the applicant, the Massachusetts racing license at Plain Ridge is currently in good standing. Investigators conducted a review of relevant investigation reports from 1997 through 2007. This inquiry it revealed a record of certain incidents, allegations, and conduct that was investigated. Although these investigations were 10 years or more old and they did not lead to the imposition of any formal regulatory sanctions or criminal prosecution, and indeed most occurred during the PRC ownership period, which preceded Arway involvement, the involvement and or continued presence of some of the individual persons involved in investigations, and particularly the nature and scope of some of the allegations, clearly merits reporting to the Commission. The more detail about the individual instances in the report, but just to highlight for the Commissioners, in 2000 there was an investigation into unlawful telephone wagering. Both Punkowski and Peterson were questioned during this investigation. Notable is that Punkowski testified before the Racing Commission he would provide additional information about suspect checks, but nothing was ever produced and no law enforcement or regulatory action was taken. In addition, in 2003, there was another investigation concerning the activity of what's called 10%ing. This is the process whereby a pari-mutuel clerk obscures a winning bettor's identification by using the name and social security number of another person for completion of the IRS W-2G forms to report the winnings to the IRS for tax purposes. This other person, rather than the actual winner, takes the reported winnings as income and receives a 10% commission. The actual winner thus avoids taxation. Several pari-mutuel clerks at Plainridge who were interviewed confirmed at that time that the 10% activity was ongoing and widespread. The investigation culminated in July 29th of 2003 when they appeared at Plainridge and took possession of W-2G forms to examine the signatures to identify the alleged 10%ers. After the W-2G forms were provided to investigators, an attorney for Plainridge called the Massachusetts Racing Commission the same day asking for the return of those forms. Although at the time there was no claim by Plainridge Track Management that the W-2G forms were illegally obtained, one of the racing commissioners ordered that the investigators return the forms to Plainridge, which was in fact done. As a result, without this documentary evidence, investigators were unable to further pursue the investigation. In 2003, an employee of the racetrack confiscated a loaded syringe and, in contravention of Racing Commission regulations, kept it in his office for 2 weeks instead of turning it over to investigators, only after being confronted about it. In 2004, there was an investigation regarding a telephone line split and suspected interception. This case was referred to the Attorney General's office. However, no criminal violations could be substantiated in that matter. Of additional concern, particularly to me, an employee was interviewed during the course of this investigation who indicated that Punkowski gave him orders not to speak with the state police assigned to the track. If the employee did speak with the trooper, he was approached by Punkowski and ordered and questioned as to the contents of the conversation. Additionally, the employee was instructed by Garen Punkowski never write anything down. And now, direct your attention to the individual and entity qualifiers and give just a summary overview of their review. All qualifiers were subject to scrutiny, including the analysis of financial and tax returns, litigation history, licensing history, political contributions, a criminal record, and driver's license check, open source information, and further analysis as described in the report itself and my cover letter to the Commission. There were the entity qualifiers that were investigated, obviously Arway LLC, which I have already, the applicant, which I've already discussed in detail, and the concerns are noted. In addition, investigators checked Massway LLC. This is the holding company for the ownership and investment interests of Fulton and Arway, which was formed in 2005. It's called referred to as a disregarded entity by the IRS. It doesn't file tax returns. Financial activities flow directly to Fulton's personal tax returns. In addition, investigated My Way Management Incorporated. This is a non-economic member and manager of Massway, which was formed in 2003. And also Anchor Partners, formed in March of 2000. The sole purpose of that entity is for lending money to the applicant Arway. This is owned by Mr. Fulton and Mr. Ross. The loan was made in 2000. That still has not been paid. They are a creditor. Their little bank activity for this entity consistent with its reported function. All three entity qualifiers presented sufficient evidence to be deemed suitable No material concerns raised. I will note, however, for the entity Our Way LLC, obviously the recommendation from the IEB was a conditional recommendation of suitability subject to their presentation to the commission regarding their business practices. As for the individual person qualifiers, start with Stanley Fulton. He's the key principal in this operation. The future financial success of Our Way is largely dependent on him. He has significant income, very significant net worth, and he could in fact fund this project. Investigation revealed that he is philanthropically generous. He was the founder and owner of Anchor Coin. As I indicated earlier, Anchor Coin subsequently was acquired by Anchor Gaming, a publicly traded company, also founded by Mr. Fulton, which was later acquired by IGT. He has subsequently sold his interest. He's the owner of Sunland Park Racetrack and Casino in New Mexico. As I indicated, by reports from the Gaming Control Board there, that is one of the better run and managed facilities in New Mexico, has a long history of compliance and cooperation. Mr. Fulton has been licensed and or found suitable in numerous gaming jurisdictions. We found for gaming licenses, 2 active and 7 inactive, racing licenses, 1 active and 10 inactive. No derogatory information was discovered concerning any of the license or finding of suitability. We discovered no litigation precluding suitability, and he has clearly demonstrated sufficient business and ability and experience through his career. We are recently notified he's going to be the CEO. Generally, he's passed muster with respect to the statutory requirements, including financial integrity and responsibility, integrity, honesty, and good character, and business ability. No material findings question his suitability, subject to the, obviously, for all of these qualifiers, subject to the condition required by the IEB in the presentation here, so I won't reiterate that for all the qualifiers. Next qualifier is Alfred Ross. He's been involved in, as I said, involved in the parimutuel racing industry since 1941. He worked his way up through that industry. He's the owner and operator of 3 dog tracks in Colorado and a dog and horse track in South Dakota. He held an ownership interest and operated Lincoln Downs in Rhode Island. Our Way is currently the only racetrack in which he has an interest. He is the 2nd largest owner. He is currently the manager of Our Way. That took place upon Gary Punkowski's resignation. He's not involved in the day-to-day operations. He does not anticipate being involved in the operational management of the proposed slots parlor. Rather, he would be involved in strategic decision-making. He is licensed in a number of jurisdictions. As to racing licenses, discovered 4 active and 6 inactive licenses confirmed. There were a few other jurisdictions where they were unable to locate the record. No derogatory information about any licenses was discovered. I will note there was an article in the Milwaukee Journal Sentinel in 2007 raising concerns about a business associate of his. Investigators did check with the Wisconsin Division of Gaming regarding the association and did confirm there was no derogatory information about Ross pertaining to this issue, and that the associate's problems arose subsequent to his association with Ross. He does have significant business ability and experience, and similar to Mr. Fulton, does appear to have presented evidence regarding his financial integrity and responsibility, honesty and good character and business ability. There were no findings regarding that would question his suitability. The next 3 individual qualifiers are the sort of the minority interest in Our Way, the smaller interest. We have Fred Chinowski. He has an ownership in Our Way. He can basically be described as a passive investor. He's been retired since 1990, stays active through philanthropic work. He's not anticipated he will be involved in the operational aspects of the project. He has no gaming license or non-gaming professional licenses. He was subject to the same scrutiny. No derogatory information was discovered and appears to have met his burden by clear and convincing evidence that he is suitable. George Chimento, also an ownership in Our Way as a passive investor. He is an attorney licensed in Rhode Island, Massachusetts, and New Hampshire. He also has held gaming licenses from the New York Racing and Wagering Board as a thoroughbred racehorse owner, the New Hampshire Racing and Charitable Gaming Commission as a thoroughbred racehorse owner, and from the Massachusetts State Racing Commission as both a thoroughbred racehorse and harness racehorse owner. No disciplinary actions were taken against Chimento in these capacities, and like Mr. Chinowski, had also presented sufficient evidence as to good character, financial stability, et cetera, to be found suitable. The next individual, Richard Tuck, also has an ownership interest in Our Way. He was the manager until 2008, a passive investor. He's been generally retired for 10 years. Prior to retirement, he was involved in a number of businesses, including Leisure Time Marketing, Venture Management Consultants, LRF Investments, and LRF Investments. He was one of the original investors in Plainville Racing Company. He was also one of the original investors, along with Ross and Anchor Gaming, Mr. Fulton, in Anchor Partners. The bulk of his income now derived from his investments. Also subject to the same scrutiny by investigators, no material issues discovered, no concerns regarding his suitability. Next individual is Mr. Grogan, who are before us today. He's the current president of Our Way. He took over after Gary Pankowski resigned. He is significant in this application because generally charged with implementing the improved internal controls, which is a critical piece to this suitability determination. He had known Mr. Pankowski for 25 years. He was originally brought into the operation as a consultant. He's well educated with the BA and a master's in business. He worked in investment banking and consulting and also served as vice chairman for the Westwood Finance Commission in his hometown. He generally will oversee the development of the proposed gaming project. In addition to his former experience in and knowledge of the regulated banking industry, this investigation has established the following additional information relevant to his suitability with respect to oversight of a gaming operation. Since taking over as president of Our Way, as promised during his April 4, 2013 sworn interview, Grogan has overseen the documentation of several policies and procedures and instituted new policies and procedures, copies of which have been provided to investigators as part of this investigation. Grogan has also sought to establish better corporate governance by, 1, implementing separation of duties between Our Way's manager and the president of operation, 2, establishing a board of advisors consisting of 2 outside advisors, and 3, the establishing of an audit subcommittee for the board, to the board of advisors. He does not have gaming, racing, or professional licenses. He does have a credibility of investment banking and financial consulting experience and a demonstrated history of regulatory compliance in that industry. He has passed muster with respect to the statutory requirements, including financial integrity and responsibility, integrity, honesty, and good character, and business ability. There were no material findings questioning suitability. Clearly, the report demonstrates a serious failing by the applicant as to internal controls up until the departure of Gary Pentowski. Grogan appears to recognize the need for the required improvements and has shown preliminary efforts in this regard over the last 3 months. He is aware that he needs to come before the commission here today and present evidence of the adoption of and adherence to these procedures to the satisfaction of the commission. It is obviously concerning for reasons I have already stated that CFO is not here to participate in that process. And that leads me to the final qualifier from the report, which is Timothy Peterson. Less than 48 hours ago, we received notice that he had resigned, and we have now received a request to withdraw. He's been the CFO since 1999, worked for several of Ross's racetracks. He's been described as more of a controller than a traditional CFO. He does the day-to-day financials rather than participate in the executive level decisions. He held a license from Massachusetts Racing in 2000. We noted no derogatory information from that license. He does not currently hold any gaming license. He did have an iOS CPA license, but let that lapse in 2003. He did make payments for the previously referenced illegal phone wiretapping investigation. He said during the sworn interview that Gary Pankowski advised him and these payments were for promotional services. Clearly, he had knowledge of the Gary Pankowski money room practices, and that in that particular avenue, I think his testimony here would have been extremely relevant. It was documented that he contacted the outside auditor to create a record of that issue. He has a credible history of accounting experience and a demonstrated history of regulatory compliance. However, as to suitability, I can find it completely unacceptable that despite the Commission's directive that he appear here today, he has chosen not to do so. The burden is on him to show by clear and convincing evidence that he is suitable, and I think this is a major failing on his part to disregard the requirement of the Commission and not appear before you today. Overall, as the Commission is aware, this was not an unconditional finding of suitability. The applicant needs to come before the Commission and meet its burden. And as stated in my cover letter to the Commission, that the attached report details concerns regarding the lack of historical corporate governance and effective internal controls under the former president. The new controls in corporate governance, which the applicant either have been or will be implemented by new management, does confirm the applicant's recognition of past shortcomings and further reflects an acknowledgement that new and more comprehensive oversight, internal financial controls, record-keeping, and experienced personnel selection will be necessary if casino gaming were to be undertaken. The applicant pledged its commitment to such improvement. As such, the IEB recommends the Commission require that the applicant institute these new internal controls immediately, and the applicant present evidence of adoption of and adherence to these procedures to the satisfaction of the Commission, and so that's why we are here today. So that concludes my summary of the report. I'm certainly happy to answer any questions by the Commission.
Thank you, Director Wells. Why don't we, it's a 11:45, why don't we finish the reactions from the commissioners or the applicants? We'll finish this, the Bureau's presentation, then we'll take a lunch break and go to the applicant. Were there any questions, first of all, from the applicant?
At this time, we would defer our questions.
Okay. Commissioners?
I had a couple of questions. Director Wells, I was particularly concerned in reading the report about state police investigations.
Correct.
When I read that section, it appears to me that there were real efforts on behalf of the management team to thwart investigations or a complete lack of cooperation, which of course makes it difficult for any agency trying to be responsible for the regulatory and criminal activity. Is that your understanding in reading that as well?
Yeah, I certainly have concerns, although I recognize that there was no regulatory action or criminal enforcement action taken as a whole,
But
and you read
would
this-
that have been possible without the
Well, that's-
cooperation on behalf of the agency regulating?
Exactly, so I think that that certainly raises concerns, and as a part of these new internal controls and procedures, and basically how they do business, working with law enforcement in a cooperative manner should be part of that analysis.
Is it also your understanding that all of these deficiencies were brought up by the IEB? The applicant themselves were either not aware or had not taken steps to solve some of these issues until they were brought up by this investigation? Is that accurate?
The timeline of how things occurred and when, and the reaction of individuals associated with the applicant when this information was brought up would confirm that, correct?
This is relative to the money room practices.
Correct.
Yeah.
Or all of the other
Well-
issues?
Well, the other ones, the earlier problems in 2004, 2003, they were already on the record. That wasn't discovered by us.
Well, I'm just saying that there was no action taken on behalf of the management team
To tighten things up.
change. Yes.
Gotcha.
That's correct.
Other questions from the commission? Commissioner?
None of this time.
All right, I'm going to suggest that we adjourn for how long? It's 10 minutes to 12. We come back at 1:45.
Oh.
Is that all right? 1:45? All right, we will adjourn for lunch and reconvene at 1:45.